This is Franklin Rye, and welcome back to Political Spirits. We still stand for the proposition that the left and the right should have a few drinks and talk. Compromise is not a requirement. If those discussions result in us changing or even abandoning our positions, that's fine. If they don't, that's fine too. We just need to talk to each other. In that way, we can unify through speech. And if the discussion becomes a bit heated, at the end of the night, we should still be able to split up the bar tab and be on our way. So what are we going to talk about this week? Let's talk about how your rights are in jeopardy in college. When I grew up, the concept of the presumption of innocence was ingrained in me and my fellow students at all levels throughout the educational process. Even in elementary school, we learned about it. And even when casually discussing issues which didn't actually involve legal proceedings, we always seemed to be operating aware of the presumption of innocence. Lately, though, we keep encountering pushback on the concept, most prominently recently in the case of the Kavanaugh Supreme Court nomination fight. The point is made that this isn't a court. There need not be a presumption of innocence. There need not be proof beyond reasonable doubt. Now, I discussed this in a prior episode, specifically in the context of the Kavanaugh hearings and in the context of the Believe the Victim mantra which was being pushed by opponents of Kavanaugh's nomination. But now I want to engage in a broader discussion that goes beyond the presumption of innocence but is limited to what is happening and has been happening on college campuses. There are two organizations which I highly recommend following if you have anywhere near the level of concern that I do about infringement of individual rights on college campuses. The first is Campus Reform, which has a website called campusreform.org. The second is the Foundation for Individual Rights in Education, or FIRE. Its website is thefire.org. Campus Reform describes itself as America's leading site for college news and as a watchdog exposing bias and abuse on college campuses. FIRE describes itself as dedicated to protecting student and faculty member rights, including free speech, free association, due process, and religious liberty, among others, on American campuses. Both organizations are very worthy of our support. Campus Reform reports in its December 19, 2018 edition online, in an article by Katie Anderson entitled Report, Innocent Until Proven Guilty, Not a Sure Thing at Majority of Top Schools. The report shows that over 70% of the top 53 colleges and universities in the U.S., quote, do not guarantee that students have the presumption of innocence when it comes to disciplinary hearings, close quote. It goes on to note that none of the top universities employed a, quote, meaningful presumption of innocence, close quote, as to sexual assault allegations. The report also found that less than one-third of the schools required a substantive hearing to support taking a disciplinary action. So how bad can this be, you might be asking? All you have to do as a student is make sure you conduct yourself properly and you shouldn't be worried, right? Well, let's go through some of the eye-opening examples of outrageous conduct by campus administrators regarding investigations and disciplinary actions taken against students. But before we do that, let's look briefly at the key development that led us to the situation where universities felt so free to deny due process in the context of sexual assault allegations. On April 4, 2011, a letter from the Department of Education under the Obama administration was sent to colleges and universities nationwide, approximately 4,600 in total. The letter, and additional guidance which came later, set out what universities must do to address the purported previous failure to deal with sexual assault. The letter advised the institutions to adopt the preponderance of the evidence standard of proof. In other words, just over 50% likelihood that the accused is guilty, instead of the clear and convincing evidence standard or the proof beyond a reasonable doubt standard, which is the standard in criminal cases. Restrictions were also placed on the ability to question the accuser, and use of a single investigator model rather than of providing for a separate investigator, judge, and jury was recommended. In other words, the single investigator is by him or herself the investigator, the judge, and the jury. The letter asserted that the federal government was taking this action pursuant to Title IX, which prohibits discrimination based on gender in providing education. Thereafter, the administration continued to push the issue, including publishing a list of schools it advised it was investigating for Title IX violations for failure to follow the guidelines in the various letters issued by the Department of Education. Not surprisingly, in response, colleges made sexual assault allegations a priority, and the traditional due process protections that we've grown to expect were not provided. Look at the Atlantic.com article by Emily Yaffe entitled The Uncomfortable Truth About Campus Rape Policy, dated September 7, 2017, for much of this background. So here's an example of one of the cases that's troubling. This one is mentioned in the Atlantic article. Matt Bormeister, a kicker for the University of Southern California football team, was expelled for hurting his girlfriend, based on a complaint made by a third party, not by the girlfriend. Bormeister was immediately suspended before the investigation, and a no-contact order was issued. However, he and his girlfriend continued to have contact off campus. His girlfriend has issued a statement through her lawyer to the Los Angeles Times attacking what she describes as a false accusation about her boyfriend, stating that he did nothing improper to her and alleging that the Title IX administrators treated her in a dismissive and demeaning way, misrepresented and misquoted her, and referred to her as a battered woman. Bormeister filed suit against the university, and he and the alleged victim were still dating as of the date of the Atlantic article. One interesting point: Bormeister is just 2 classes short of graduation. Here's another example, this one described in a Washington Post article entitled Campus Due Process in the Courts, dated February 1, 2017, by Casey Johnson and Stuart Taylor. 2 male students at Brandeis University ended their relationship on less than amicable grounds. One of the students filed a sexual assault complaint well afterwards with the university, which listed his former boyfriend's offenses as including sometimes looking at him in a state of undress while they were in a shared bathroom, and sometimes waking him up with a kiss. The complaint also alleged that their intimate relationship began with the non-consensual placing of a hand on an intimate but clothed area, but the sex thereafter and for the entire duration of the relationship, up to 21 months, was consensual. The university violated its own rules by not providing a hearing for the accused. It used a single investigator as both investigator and the judge to decide the matter. The accused was not allowed to know the details of the charges, to see the evidence, to have representation by counsel, to cross-examine any witnesses or the accuser, and the right to appeal was so limited that it could not result in a finding of the investigator being overturned as being incorrect or arbitrary or not supported by the evidence. The investigator's conclusions included a finding that the accused kissing the accuser while he was asleep next to him constituted sexual misconduct, because a person who is asleep is incapacitated and therefore not capable of giving consent. The investigator concluded that the accused had engaged in sexual misconduct, sexual harassment, and invasion of privacy in violation of Brandeis policies. Her conclusions also included a finding that the accused had engaged in violence based on Brandeis' definition of sexual violence that the court noted, quote, encompassed virtually any form of unwanted sexual activity, close quote. The disciplinary action taken was a disciplinary warning and a permanent notation in the accused record that he had committed, quote, serious sexual transgressions, close quote. The accused has stated that he has encountered difficulties with obtaining employment because of knowledge obtained by potential employers regarding the determination. The accused lawsuit against Brandeis University withstood a motion to dismiss, and the judge provided a perfectly on-point commentary regarding what I think is the most ridiculous of the findings of the investigator. Specifically, the court noted, quote, special examiner's findings concerning the, quote, kissing, close quote, instance are particularly noteworthy. The special examiner concluded that John had occasionally wakened J.C. with kisses and had sometimes continued to kiss him after J.C. said he wanted to go back to sleep. She further concluded that those actions were acts of violence. To reach that result, she essentially stitched together a series of broad generalizations. Kissing is sexual activity. A sleeping person is physically incapacitated and therefore cannot give consent. The existence of a relationship is not relevant to consent. Sexual activity without consent is sexual misconduct. Sexual misconduct is a form of violence. To reach a conclusion that seems at odds with common sense and the ordinary meanings and definitions of words. In short, the existence of a relationship was unquestionably a central issue in assessing John's behavior and resolving the issue of consent. The existence of a relationship did not immunize John from the consequences of any improper behavior, but neither should it have been dismissed out of hand simply on the basis of a broad generalization that sexual misconduct can, and sometimes does, occur in the context of a relationship. Close quote. The judge absolutely nailed it on the head. I don't know how on earth the special examiner ever reached the conclusion that she did. If you're married or in a long-term relationship, think about how many times you've woken your spouse or significant other with a kiss. Now think for a moment that if you were a student at Brandeis University and you had a difficult breakup with your spouse or significant other, you could be subjected to an investigation conducted by what I consider to be an incompetent special examiner with nearly none of the due process protections we've come to expect, and have that special examiner conclude that by awakening your spouse or significant other with a kiss, that you had engaged in violence. In what world was the special examiner living? How is it that our universities are producing these ridiculous results? Well, in this case, it arose out of the response to the pressure from the Department of Education in the Obama administration. I should note that the Department of Education under the Trump administration has revised those standards being pushed on universities, and they now include significant due process protections, including a commitment to cross-examination. However, incredibly, some universities have insisted they're going to continue following the guidance from the Obama administration. So we'll have to wait and see just how much improvement there will be as a result of the new guidelines from the Trump administration. Next topic. Hate crime hoaxes. Many of you have been following the claim by Empire actor Jussie Smollett that he was attacked in Chicago and beaten up by two men who stated, quote, "This is mega country," close quote, called him racial and homophobic slurs, and put a rope around his neck and poured a substance on him that Smollett asserted smelled like bleach. Smollett, who's an African American and a publicly acknowledged gay man, went public with his claim and received quite a bit of sympathy, including expressions of support from multiple celebrities and politicians, some of whom connected the attack he described to an atmosphere that they said was created by President Trump. My initial reaction was the same as many on the right who were very suspicious. The story just seemed too tailor-made for the left-wing narrative. That didn't mean it wasn't true, it just meant it was worthy of skepticism. The facts making it worthy of skepticism including the fact that it allegedly occurred during the polar vortex with temperatures well below zero. It didn't seem likely that somebody was going to go out in those conditions for the purposes of attacking someone for being black and gay. Once again, it didn't mean it didn't happen, but it seemed strange. Later, others pointed out that it seemed odd that Mr. Smollett didn't promptly call the police, was filmed walking by the security desk at his apartment building without bringing it to the attention of the security person, was still carrying his package from the Subway sandwich shop after having purportedly been beaten up, still had a rope around his neck when he walked by the security person, and still had a rope around his neck when the police arrived over 40 minutes later. Others have noted that it just doesn't seem likely that in the incredibly liberal town of Chicago, Trump supporters would be roaming around looking for a victim. Add to those odd circumstances the fact that Smollett was unwilling to provide his cell phone for examination to the police to back up his claim that his agent overheard the attack. Thereafter, The police were able to review video obtained from various security cameras that covered all of the time from Smollett's visit to the Subway sandwich shop until he returned to his apartment building, except for approximately 1 minute. 2 persons of interest were identified in the videos on the other side of the street from Smollett, and he thereafter advised he was sure they were the perpetrators. Well, now it turns out that the 2 persons of interest identified in the video are Nigerian bodybuilders who were extras on the Empire TV series on which Smollett is an actor, and they've periodically worked out with him. As Nigerians, they are, of course, black, and they certainly didn't fit the profile that was depicted of the white attackers who purportedly yelled, "This is MAGA country." The Chicago police arrested them and held them for 2 days, during which they obviously engaged in interrogation, and then they released them without filing any charges. The police noted that they now had to conduct further investigation. Police thereafter have said that there has been a change in the case. They are also no longer describing Jussie Smollett as a victim, and they're saying that they need to talk further with him. It doesn't take much to read between the lines. It seems obvious that they gained additional information from the Nigerians during the interrogation, and now they're investigating it. It certainly seems likely that this was a hoax. One theory out there is that Smollett was going to be cut from the show Empire, and he was trying to keep his name in the news by reporting a fake attack by non-existent Trump supporters. Local Fox 32 is reporting that sources within the Chicago PD are saying that the Nigerian bodybuilders have stated they were paid by Smollett to perpetrate the incident. If this was indeed a hoax, I hope that Smollett is prosecuted very aggressively. Incidentally, Jussie Smollett has hired one of the most prominent defense attorneys in the country. It looks like he may well see the writing on the wall. Making up attacks pulls precious police resources away from investigation of actual crimes. We should all be able to agree that persons who pretend to be victims of these hoax crimes should go to jail for a very long time. If you think that I'm overreacting, let's talk for a moment about how many of these hoaxes have been perpetrated. Often the original allegation of a hate crime is given tremendous amounts of publicity, but when it's discovered to be a hoax, it often doesn't get as much attention because it doesn't fit the left-wing media's narrative, and the publicity at the national level tends to come primarily from more right-leaning sites, such as Fox News, for example. As a result, many who are left of center or who don't closely follow the news never hear about the fact that a reported hate crime turned out to be a hoax, and remember only the original report of the hate crime. So how many hate crime hoaxes am I talking about? Well, if you go to the website fakehatecrimes.org, they list what appears to be 349. Now, you'll see from their notes on some of them that not all of them are really fake hate crimes. Some are examples of the media falsely depicting an incident as an expression of hate, for example, and some are still under investigation after receipt of contrary evidence. But the vast majority are in fact instances where a hate crime was alleged by the purported victim and it turned out to be unsupported by the evidence, or one which resulted in a determination that it was a hoax, and many of which were actually prosecuted. I recommend that you look through the list. It includes links to media coverage of the instance. I suspect you'll be shocked by the numbers. Here are some examples. As reported on ABC13.com, on September 17, 2018, 19-year-old Adwoa Lewis was charged with fabricating a story about a Trump-related hate crime. The African-American young woman had said that 4 teenagers approached her and yelled, "Trump 2016," and that she didn't belong there. She also said that the next day she woke up to find her car slashed and a note that said, "Go home." Yahoo News reported on July 24, 2018, that a Texas restaurant had banned a customer after a mixed-race employee claimed the customer had written, quote, "We don't tip terrorists," close quote, on the receipt. The employee's statements about the incident had gone viral, with some 8,000 comments on Facebook. But the Yahoo News article indicated the restaurant later announced that the employee was no longer employed by the company and that the story had been made up. PilotOnline.com, the website of the Virginian Pilot newspaper, reported on April 10, 2018, that police had charged a 13-year-old girl with falsely reporting that she had been held at knife point by a man that had ripped off her headscarf and called her a terrorist. NavyTimes.com reported on December 8, 2017, that the U.S. Navy had announced that, quote, a sailor who claims someone scrawled racial slurs on his bed aboard an aircraft carrier, sparking a viral Facebook post in the process, staged the incident himself, close quote. The Daily Caller reported on November 7, 2017, that KKTV.com, a local television station, reported that an Air Force Academy cadet allegedly targeted by racist remarks on whiteboards outside of dorm rooms was actually the one who wrote the racist messages and that he admitted responsibility. The Wichita Eagle newspaper at the website Kansas.com reported on November 8, 2018, in an article by Jason Tidd with the headline, quote, for second time in 2 years, racist slur at Kansas State was a hoax, police say, close quote. The person who reported the incident admitted creating the note with the racial slur on it. The headline says it all. Pix11.com, a Tribune broadcasting site, reported on May 27, 2017, that a Queens College student of Pakistani descent who said he had been robbed by 3 masked men hurling racial slurs at him, yelling at him to get out of my country, had recanted his story and said it didn't happen. Tribstar.com, the website of the Tribune Star newspaper covering Terre Haute, Indiana, reported on April 21, 2017, that an assistant professor at Indiana State University had been arrested on charges of making false reports of anti-Islamic threats against him and reporting an attack police said did not happen. Syracuse.com reported on March 21, 2017, in an article by Ben Axelson that, quote, a Jewish man in upstate New York was jailed on Monday for falsely reporting racist vandalism to police, close quote. Specifically that he reported to police that his home had been vandalized, but the police concluded he had actually painted the 3 swastikas on his home himself. TheCollegeFix.com published an article on February 24, 2017, entitled, quote, Hate Crime Hoax Alert. Capital University student admits to fabricating several incidents, close quote. The article details that senior Jalen Mitchell confessed to submitting multiple false reports to campus police. The instances included an allegation that he'd been attacked by a white man with a knife. The student acknowledged that he had filed the false reports to, quote, get attention, close quote. TheCollegeFix.com reported on November 13, 2016, that anti-Latino graffiti at Elon University, specifically Bye Bye Latinos, Hasta la Vista, printed on a whiteboard, had actually been placed there by a Hispanic student who said he did it as a joke. The student had apparently said he was upset about the results of the election and had written the message, quote, as a satirical commentary, close quote. The university refused to release the identity of the student, saying it was protected by law. The author of the article, Dave Huber, expressed skepticism about the explanation that the comment was a satirical commentary and speculated it was more likely that the student was trying to spark an uproar over a hate incident when none had occurred. I agree with that speculation. There are so many of these that I could go on forever, but I won't, of course. So I'll give you one last example. WBRZ.com reported on November 10, 2017, once again right after the election, that a University of Louisiana at Lafayette student had admitted to lying about being attacked by 2 white men, one of whom she said was wearing a white Trump hat. She had claimed that the man had struck her with a metal object and stolen her wallet and hijab. Keep in mind, I've given you just a small sampling of hoax hate crimes over the last couple of years. This is an epidemic, and it seems we are close to confirming that the most recent outbreak in this epidemic was perpetrated by Jussie Smollett. This is absolutely out of control, and it must be stopped. Every one of these incidents undermines the ability of people who have actually been subjected to criminal conduct to have those crimes investigated and the perpetrators prosecuted when found. The only way this is going to stop is if three things happen. First, the police and prosecutors must aggressively investigate and pursue the perpetrators of any hoax crimes. Second, the judges must throw the book at anyone convicted of perpetrating a hoax crime. I'm not talking about home confinement or counseling. I'm talking about major jail time, years in jail, not months. Finally, the media, particularly the national media, has to return to engaging in actual journalism. As I noted in episode 8 of this podcast entitled Unified Through Speech, in the segment where I talked about what has happened with CNN is a shame, I remember when CNN used to actually engage in journalism. What they do now is a disgrace. The real journalism engaged in with regard to the Jussie Smollett's matter was by local media in Chicago, such as the Fox 32 television station. Right-of-center national publications such as Breitbart News did a pretty good job of following this story. But the real journalistic investigative work was done by local outlets such as Fox 32. This story was seriously questionable from the very beginning. The national media outlets, especially CNN, need to engage in some real soul-searching about the way they handled this story. Anybody who wasn't skeptical about a story that perfectly fit the left's narrative about Trump supporters, that involved two purported Trump supporters tracking down a TV star in Chicago during the polar vortex in extremely cold temperatures, attacking him, putting a rope around his neck, pouring bleach on him even though the temperatures were well below the level at which household bleach freezes, but somehow apparently not managing to damage his bag from the Subway sandwich shop, with the attack never appearing on any of the multitude of security cameras that were surveyed by police, the TV star never reporting the incident to the security guard at the front desk of his apartment, and then refusing to provide his cell phone to police so that they could investigate his claim that his agent was on the line when the attack occurred. Any journalist who wasn't skeptical of those facts needs to find a new career. Do I think the national media will engage in that soul-searching? Not a chance on earth. Well, there's more than one chance on earth that I'll be back next week with another episode of Political Spirits. I look forward to it, and I hope you do as well. Be sure to tell your friends about Political Spirits, and follow me on Twitter at Franklin Rye. This is Franklin Rye. Thank you for listening.